Our first case this afternoon is People of the State of Michigan versus Trevor McLeod. It's file 23-6748FH. Counsel, you want to state your appearance, please?
Anthony Julian on behalf of the people.
Okay, Mr. McLeod, are you present, sir? You want to come on up to the table here?
I want to reserve all my rights.
That's fine, I'll. All right, so Mr. McLeod, this is the time and date scheduled for what's called for a circuit court arraignment. The case having been bound over to this court by the district court. So you're here representing yourself today, is that correct?
Yeah.
What's that?
Yep.
Okay. So I'm required by law to make sure that I've taken an initial waiver of your right to counsel in this court. So I covered a pre-trial hearing in the district court, so we talked a little bit about this, but now it's up in my court. So you've got two constitutional rights. You can have you have the constitutional right to be represented by an attorney, and if you wanted to have an attorney at public expense and qualified, to have that. You also do have the right under our Constitution to represent yourself. Obviously, you can't do both things at the same time. So do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No. So
hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
I don't understand the nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? Is that okay?
Sure.
Okay. So one step at a time, I need to establish that you're exercising your constitutional right to represent yourself validly. So for me to do that, somebody might decide they want to do that and they really don't understand what's at stake. So I have to establish on the record that you do understand what's at stake.
Well, I think you have to establish on the record first that you can have jurisdiction. That's been questioned. It was questioned in preliminary hearing. It was never addressed.
I'll address that today.
Well, it has to be addressed before anything can move forward, obviously.
Okay, so you want me to explain to you why I have jurisdiction?
Yes.
Okay, let's do that first.
Jurisdiction it's under.
Sure. Okay. This court has subject matter jurisdiction over crimes punishable by more than a year as the court of general jurisdiction under the Michigan Constitution of 1963. The people voted to ratify that Constitution. That is the underlying law of our sovereign state of Michigan.
Okay, so is that a jurisdiction under criminal? Or is it military?
Yeah, it's a criminal charge against you, and I have jurisdiction over that.
Okay, so the Constitution of the United States only grants you two criminal jurisdictions. One's common law, and one is military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Which of these two criminal jurisdictions is that?
You're not in federal court. It's not a federal crime you've been charged with. You've been charged with violating the law of the state of Michigan. And, hey, what's going on over there? What are you doing, sir?
I'm trying to make sure that this is going live. It's not happening. There's something messed up with your film and I'm trying to straighten it out. I was just checking to see if it was recording or not.
Sit down. Sit down. You're disrupting my courtroom.
Sorry, sir.
It's live. Any more disruptions, I'm gonna ask you to leave.
So common law,
Cloud, you're in a state court. You're charged with violating a law of the state of Michigan.
is that a statutory jurisdiction? What is it?
Yeah, it's a statute. And,
Okay, so-
and this court is duly authorized under Article 6 of the Michigan Constitution. So that's my jurisdiction.
Okay.
So now I need to make sure that you're establishing your right to represent yourself. So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine.
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. The legislative power is exercised by the House of Representatives and the state Senate. They have passed statutes that the governor has signed. The prosecutor's office is alleging that you have violated those statutes. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney would, Drew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. Okay, so Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod,
the
stop.
court can be,
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
you know, I understand you want to object to things, and you're going to be allowed to object to things, okay?
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt, and you'll go back to a jail cell for a while. and then we'll do it.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws, I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal it.
There's no
to the
such thing as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? God's sake. Protecting my rights is really so nice. I'm sorry.
Fucking joke.
This isn't true. You guys are
Follow
following
unconstitutional
You're following
orders.
unlawful orders. It's not
Not a
constitutional
good
at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day in Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
Mr. Mathis and Mr. White. All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both to the courtroom and also online. And we'll call the case of People of the State of Michigan versus Trevor McLeod. It's file 23-6748FH. How do you want to interrupt the table, please?
All right, reserved.
Mr. McLeod, we were here last time and tried to conduct the arraignment, and you ended up being held in contempt, and so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of the Michigan Supreme Court, and they make me go through certain things.
Sure.
You're here without a lawyer. So I need to obey the Supreme Court and establish certain things so that I can make sure that you can represent yourself. So you've got the right to represent yourself or to have an attorney represent you. You can't do both at the same time. So I need to establish which one you're choosing. So to do that, I have to first advise you of the maximum charges that you face. Count 1 is a charge of resisting obstructing a conservation officer with a habitual second notice. It's a felony punishable by up to 3 years and or $1,000 fine. Count 2 is operating a motorboat while intoxicated. That's a misdemeanor, punishable by up to 93 days and or $100 to $500 fine and or 45 days of community service, suspending the privilege to operate a vessel, cost of prosecution, or emergency response. Mr. McLeod, do you understand the maximum possible sentences for those charges?
Can I say something for the record?
No. I'm asking you a question. Do you understand the maximum punishments that you face?
I don't accept those charges. I got a treaty right here that says I wasn't doing anything wrong.
That's for later. All right, Mr. McLeod, you apparently want to do this the hard way again. I'm just asking you if you comprehend the maximum penalty that they're charging.
I
you.
comprehend.
Okay. All right. So, do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I comprehend.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because the 1836 Treaty of Washington, which was further codified in 2017, consent decree, states that my vote is not legally registered, which makes this unlawful investigation fruit of the poisonous tree.
Okay, so you wish to represent yourself in this
I'm
matter.
presenting myself.
Okay. And has anybody promised you anything or threatened you in any way to get you to waive your right to an attorney, or are you doing that of your own free choice?
It's not my free choice, it's under duress, but I'm here to do it, so.
Oh, you mean that you're not choosing to be here because of the charges? I just mean, so nobody's like making you give up your right to an attorney. Well, I said you've got the right to an attorney. You don't want to have an attorney. Is that your choice, or is somebody like pressuring you to not have a lawyer?
What's pressure to be here?
That's not what I asked.
Okay, well,
Is anybody pressuring you to give up your right to have a lawyer?
no.
Okay. See, I'm not asking you trick questions. I promise you, Mr. These are not trick questions. All right. So I'm also required to make sure that you are doing this with open eyes, meaning that you understand the risks of self-representation. So as you found out last time, this court has procedures that this court will follow. And when people refuse to follow them, there will be consequences for that. If you're representing yourself, you're going to be held to those same procedures just like a lawyer would. Do you understand that? Do you comprehend that?
I comprehend that this court does what it wants and violated the due process when they arrested me, so we lost subject matter jurisdiction. This whole thing is a shame.
That's not what I asked you.
Okay.
Do you comprehend that I'm going to hold you to the same standards of procedures that I would to an attorney?
I don't think that's how it should be done. I think there's case law that says that people, when people present themselves, they have different standards.
Well, they don't. I mean, I try to work with them as I am with you. I can promise you I don't have these types of conversations with lawyers at the arraignment because they know what they're doing. So I'm trying to give you a little bit more leeway. But you have to follow the procedures as they are dictated by the Supreme Court and the court rules, and as I say them to be. Not what you think they ought to be, but what I say they are. Do you understand that?
I don't understand. I comprehend it.
Okay. All right. Now, because of that, attorneys have had to, be licensed to understand those rules and have degree from a law school where they've spent 3 years studying those rules. And so there may be things that they're aware of that you may not be. So when somebody represents themselves, there may be a defense to the charge where a lawyer might recognize that defense and present it, and somebody representing themselves might miss that defense. So when you represent yourself, you take the risk of that happening. Do you comprehend that? All right. So let me give you an example of that. So about 2 years ago, I had somebody in my court in my other county, similar to your beliefs about the law. And this defendant was raising similar claims as you're seeking to raise here. And they didn't prevail because courts don't agree with those claims. And the person became so disruptive, I withdrew their permission to represent themselves, and I appointed an attorney for that person against their will. The attorney recognized that there was a defense to the charge filed a motion and I dismissed the case on the attorney's motion, the person representing themselves would have never recognized or did not recognize that defense. So do you understand, when you represent yourself and give up the right to be represented by a trained attorney, you're taking a risk that there may be defenses that you might miss.
I comprehend what you're saying,
Okay.
so I think you just move forward from the attorney.
All right. So then the final thing that I have to decide is whether your self-representation will disrupt, unduly inconvenience, or burden the court and the administration of the court's business. If I'm judging it just on last time's appearance, I would say, well, yeah, you're going to be disruptive, so I'm not going to let you represent yourself. Today, you've been tempted to go down that road, it seems to me, but you've trained yourself. So I'll at this point find that you representing yourself is not going to unduly disrupt, inconvenience, or burden the court's business. But you should understand, Mr. McDowell, that changes when you decide that you're going to run this court, which you do not. Then I will withdraw your authority to represent yourself, and I'll appoint an attorney to speak for you, and you won't be allowed to speak. But as long as you're going to, follow the proper procedures, at this point, I'll let you represent yourself. All right. So I will find that Mr. McLeod is unequivocally waiving his right to counsel. He's made that right knowingly, intelligently, and voluntarily, and he's aware of the disadvantages of self-representation. And at this point, I'm finding that his self-representation will not be disrupted to the court's business. All right. There. Now, Mr. McLeod, I have to arraign you on the charge itself. Have you been given a copy of the document called information felony, the charging document that contains the charges against you? Okay. You would have the right to have me read that document in full on the record. Do you wish me to do that, or do you want to waive the reading of the information?
I guess it's for procedure.
Okay. So count one charges you with resisting, obstructing conservation officers, and it alleges that you did knowingly or willfully obstruct, resist, oppose, assault, beat, or wound C.O. Layston Feltz, an officer appointed by the Director of the Department of Natural Resources when said person was making an arrest or search contrary to Michigan law. That's normally a high court misdemeanor punishable by 2 years and or $1,000 fine. There is a habitual offender second notice indicating that the court should take notice that you were previously convicted of a felony or an attempt to commit a felony in that on or about February 12th, 1996. You were convicted of the offense of larceny from a motor vehicle, violation of Michigan law, in the 53rd Circuit Court for Sheboygan County. Therefore, that increases the maximum penalty to 1.5 times, meaning that resisting obstructing charge is punishable by a maximum of 3 years and or $1,000. Count two, marine safety operating while intoxicated, alleges that you did operate a motorboat on the waters of the state while you were under the influence of alcoholic liquor contrary to Michigan law. That's a misdemeanor punishable by 93 days and or a $100 to $500 fine and or 45 days community service. Court to suspend privilege to operate vessel 1 year to indefinite, and the court can assess the cost of prosecution or emergency response. All right. Mr. McLeod, how do you wish to plead to those charges? You can either plead guilty, not guilty, or you can stand mute.
I don't plan on pleading because I have a decree right here that says I wasn't violating any laws. Stop it and lawful, which makes everything after approved by the district. So
Well,
that's for evidence. Copy of my tribal card, a copy of the excerpt from the 2007 consent decree.
Well, that would be like a motion to dismiss later on, which you could file. In fact, you had filed a couple motions to be heard today, and then you withdrew them. If you file motions and want them heard, I will hear them. I'll hear your arguments and I'll rule on them on the merits and the law and the facts. But you can't skip the entering of a plea and go right to a motion. So I first have to enter a plea, either guilty, not guilty, or you can stand mute and refuse to enter a plea. Am I understanding that you are refusing to enter a plea? Which is fine. That's not a violation of court procedure. It's one of your options. You have three options right now: to enter a plea of guilty to the charges, to enter a plea of not guilty to the charges, or to decline to enter a plea to the charges. Which of those three options?
I decline that.
Okay, that's fine. That's your right to do so. So Mr. McLeod is standing mute as to the charges. The court will enter a not guilty plea on his behalf. Your Honor. Well, I'm sure you don't want me to enter a guilty plea, so I have to enter one or the other.
Not guilty on behalf of you practicing law from the bench. So are you finding it official determination that I'm not guilty?
I do not have to subject myself to your cross-examination, Mr. McLeod. That's not how this works. All right, so I'm going to enter a plea of not guilty on your behalf. Mr. Juliet, are the people requesting a referral to the Forensic Center?
No, Your Honor.
I don't see any indication that Mr. McLeod is incompetent to stand trial, so I won't make such a referral on the court's own initiative. All right, so Mr. McLeod, the other thing I have to do today is kind of pick a day for us to come back, hear any motions that you may file and schedule, or the prosecutor may file and schedule, or to see if there's a resolution of the case, or to schedule a trial. And we call that a docket call, because we're calling the case to the docket. So I've got to pick a docket call date. Usually do that about a month out. So I could have you come back Tuesday, February 6th at 9 a.m. Juliet, what would be the estimated length of trial if the case went to trial?
1 day.
All right, Mr. Juliet, anything further from the people?
I received an email yesterday from Mr. McLeod. It appears to be a dispositive motion. I would say suppress the evidence. I know he filed a motion based on summary disposition a while back that was withdrawn. I would just request that if he wants to move forward with that motion to suppress, just give us a copy of the written motion. Perhaps the court can hear it on the 6th. I would just ask 7 days to respond to it.
All right. So, Mr. McLeod, I've done everything I need to do today in terms of determining whether you can represent yourself, advising you the charges, entering a plea, and scheduling our next court date. You can feel free to file any motions or objections that you want to have heard to be heard on that date. I can't rule on things orally on that regard. It sounded like today you wanted to tell me some things about a treaty and things like that. You might be right. I don't know. But I'd have to review your written materials. I'd have to review your argument. I'd have to hear from both sides and then make a decision on that. We can do that on the 6th if you file the motion and notice it up to be heard that day. Is there anything further for purposes of arraignment today?
I'd like to have the motions heard earlier than that. And I'd like to be relieved of my bond restrictions, which are quite invasive, honestly.
Well, you filed a motion to review those and then you withdrew your motion.
Because I want to put separately.
I mean, well, I guess I could make one exception to that the court rule does allow bonds to be reviewed at any time. So I do allow oral motions to review bond. So if you want to talk about your bond conditions right now, I'll certainly do that.
I think they're very restrictive. I think they're a violation of due process. I think that they're unnecessary to prove that I'm going to show up or I'm not dangerous to the public.
And review what those conditions are, because I didn't set them. Those are set by the district court, so let me review here. Which conditions is it that you are thinking are unduly restricted?
The having to call every morning to take a drug test.
Is that the only condition you're seeking to have removed?
It's really the only one that, well, not being able to leave the state is kind of silly too. I travel to work.
All right, Mr. Juliet, Mr. McLeod is objecting to the bond conditions of calling the bond line for testing every day and not leaving the state of Michigan. Any response?
If he works out of state, I have no objection to that. We're striking that from the bond condition. As far as the bond line, I mean, this is an alcohol related offense. It has been a while. I mean, there's been no bond violations, so I don't have any objection to the board striking here.
Okay, now the initial conditions downstairs did say except travel for work purposes. However, I mean, looking at this charge, I've got a misdemeanor charge. I've got a fairly low severity felony charge. So, I mean, if Mr. McLeod, if you didn't show up for court, that would be a problem. But if you wanted to, you know, go to another state for work or frankly for any other reason, I'm not sure why I would care about that. I don't think that would. I don't think this is the kind of case where you would pose a flight risk. So I am going to amend the bond conditions to remove the bond line requirement. And remove the restriction on out-of-state travel. If this were a drunk driving charge with a motor vehicle, I don't think I'd remove that because I think I'd still want to have you do testing, but I'm really not too worried. You're going to be operating a motorboat right now anyway, so I'll grant that request, Mr. McLeod, and remove those two bond conditions. The court will enter an order so that you don't have to present one to us, effectuating those changes. Anything further for today, Mr. McLeod? Okay, we'll see you on the 6th. If you do want your motions heard on an earlier date, you can contact the assignment clerk and see if there's a date we can get you in soon. All right, have a good day. All right, we'll be on recess till 10 a.m.